the Supreme Court of India recently permitted the withdrawal of life-sustaining treatment for Harish Rana, a 32-year-old who has been in coma for over 13 years after a brain injury, noting that the chances of recovery are negligible. So the case has once again brought the issue of passive euthanasia into public conversation. In your view, how do you see this key decision as, and what is your message to the parents of Harish Rana?
Thank you, PGI, for inviting me on this and for taking the time for us to talk about it a little more so that there can be further legal literacy. First, if I could please address Harish Rana's parents. It is a complicated time for them. नमस्ते, सलाम, मेरा नाम पिंकी विरानी है। चलिए कोई बात नहीं, मैं कौन हूँ क्या हूँ कोई बात नहीं है। मेन थिंग हरीश राणा के पेरेंट्स को मैं कहना चाहती हूँ कि मैं यहाँ कनाडा से आपके बेटे के केस और आपकी बहुत ही हिम्मत वाली लड़ाई मैं यहाँ से फॉलो कर रही थी, क्योंकि पैसिव यूथनेसिया का जो जजमेंट लॉ है जो कि आप कब से कोशिश कर रहे हैं, वो इंडिया में 2011 से है। एक उस टाइम पे पेशेंट थी अरुणा शानबाग और उसकी सफरिंग करीबन 40 साल तक रही, तो मैं यहाँ से फॉलो कर रही थी। ये जो लॉ जो 2011 में आया वो मैं तब इंडिया में थी, तो मैं आपके बेटे के केस के फॉलो कर रही हूँ। और अब क्योंकि आपको फाइनली इसी अरुणा शानबाग के वजह से आपको और आपके बेटे को जो राहत मिली है, मैं पहले तो आपको कहना चाहती हूँ कि आई एम एक्सट्रीमली सैड दैट आपको इतना बहुत सहना पड़ा। दूसरी बात, मैं बहुत रिस्पेक्ट करती हूँ आपको, बिकॉज ये आसान काम आपका नहीं था। आई थिंक कोई भी इंडिया में ऐसा नहीं होगा, स्पेशली पेरेंट्स जो अभी आपके साथ नहीं होंगे। बच्चे के लिए लड़ना कोई आसान बात नहीं है, बहन के लड़ना, फैमिली के लिए लड़ना, जो अरुणा शानबाग मेरे लिए हो गई थी फैमिली, ये आसान बात नहीं है और हम सब आपके साथ हैं। तीसरी और एक फाइनल बात मैं आपसे कहना चाहूंगी, पैसिव यूथनेसिया के 2-3 तरीके होते हैं। सबसे आसान वो है जहां पर सिर्फ वेंटिलेटर बंद करना होता है, दैट्स इट, बंद कर दिया, पेशेंट आराम से या आहिस्ता से चैन की नींद सो जाती है। दूसरा जो होता है वो थोड़ा और कॉम्प्लिकेटेड होता है, लेकिन ये जो आप अब गुजरने वाले हैं, इट इज एक्चुअली द मोस्ट कॉम्प्लिकेटेड। और जो आपने जो स्ट्रेंथ दिखाई है, एक्चुअली अभी आपका स्ट्रेंथ मैक्सिमम होना जरूरी होगा, क्योंकि दो प्रोसीजर अब आएंगे। जब फूड का विड्रॉल होता है, और ये दोनों प्रोसीजर के वजह से मेरी अरुणा को शांति उस टाइम पे नहीं मिली, क्योंकि दोनों प्रोसीजर डॉक्टर और नर्स ने अलाउ नहीं किया। ये 2 प्रोसीजर क्या है? ये इंटरनेशनली लेड डाउन प्रोसीजर है। ऐसे नहीं है कि हम हवा में से कहीं निकाल के कहते चलो ये कर देते वो कर देते। इट्स इंटरनेशनली लेड डाउन प्रोसीजर। 15 दिन लगता है उसमें। एक तो आप पेशेंट की फीड जो है, या नेजोगैस्ट्रिक या थ्रोट या डायरेक्टली फ्रॉम माउथ, ये फीड जो है आप टेपर डाउन करते हैं। अब इसका मतलब ये नहीं हुआ कि आप पेशेंट को भूखा मारते हैं, नो, आप सिर्फ टेपर डाउन करते हैं। और क्योंकि पेशेंट बहुत ही पेन में रहता है या रहती है, उसके साथ में डॉक्टर्स थोड़ी सी पेन मैनेजमेंट मेडिकेशन डाल देते हैं। दिस इज इंट्रावेनस, तो ऐसे नहीं कि मुंह में डाल दिया या नथिंग लाइक दैट। नॉर्मली इंट्रावेनस जो होता है कनाडा में, जहां पर मेडिकल असिस्टेंस इन डाइंग अलाउ है, या दूसरी जो अदर कंट्रीज है वहां पर अलग अलग किस्म का होता है। इंडिया में अपना बहुत ही सिंपल है, थोड़ा सा मॉर्फिन, अफीम, मेडिकली ग्रेडेड, नॉट ऐसे ही कि दुकान से ले लिया और डाल दिया, ओके, मेडिकली ग्रेडेड, and the doctors know what to do, or the nurses who are authorized by the doctors, who are now authorized by the Supreme Court. ये बहुत ही नेसेसरी है समझना, इलीगल। हरीश राणा बेचारे, गॉड ब्लेस हिम एंड गॉड ब्लेस हिज पेरेंट्स, अब उसको अलाउ किया गया है टू डाई विद डिग्निटी। What has to be done here? Taper down his feed. थोड़ा 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 कम करो। What has to be upped here? थोड़ा थोड़ा पेन मैनेजमेंट मेडिसिन। पेन मैनेजमेंट मेडिसिन 2-3 ही तरह के होते हैं, द डॉक्टर्स विल नो। ये दोनों साथ में अगर होता है तो 15 डेज में मैक्सिमम, नॉर्मली 10 डेज में हो जाता है, 15 डेज में मैक्सिमम he will have eternal peace. This is what I would like to tell Harish Rana's parents, that अभी आप हक से मांग सकते हैं, हक अब आपका है, सुप्रीम कोर्ट ने आपको हक दिया है। इसके पहले 2011 से अरुणा शानबाग की वजह से पेशेंट्स को हक मिला है, अब आप हक से मांगे ताकि आपका बेटा और आप पीसफुली एक कंप्लीशन हो, एक क्लोजर हो।
Right. Thank you so much for that. And your petition in the case of Aruna Shanbhag led to the landmark 2011 judgment by the Supreme Court of India, which for the first time laid down guidelines for passive euthanasia in India. Looking back more than a decade later now, how do you assess the progress India has made in recognizing the right to die with dignity?
When I had first approached the Supreme Court in 2009, Aruna at that time had just turned 60. So she had been in that situation, in that persistent way. First of all, it wasn't recognized as any state. It was just like, बेचारी बिस्तर में पड़ी है. And when I started researching the book, which was when she turned 50, I discovered that she couldn't see, she couldn't speak, she of course couldn't move. And the condition wasn't just a full brain dead. There was something in between. So when she reached 60 in that position, by which time this situation had been with her since the age of 24, I went to the Supreme Court and I asked exactly what is being asked now. Okay. In 2011, the Supreme Court announced the judgment law. At that time, it was Justice Markandeya Kajju and Justice Sudha. The law said, this is judgment law till Parliament ratifies it or reverses it. So that was the judgment law. Now, what did that say? We recognize passive euthanasia. So for the first time in India, it was recognized. First time. कि मतलब एक एक्टिव यूथनेसिया होता है और एक पैसिव होता है. पैसिव का मतलब क्या है? पैसिव इज व्हेन डेथ हैज ऑलरेडी सेट इन. No doctor, no science, no God can fix it for you. That's it. It's death. It's right there. You know? So then your choice is you either give the patient dignity and everybody around the patient suffers less guilt, or you become stone cold and heartless. You become like a corporate hospital and you let the bills come and you let the patient suffer. So at that time, when I asked, so the law was allowed. But in the case of Aruna, it wasn't allowed because they didn't want to taper her feed. They said things like, we'll starve her to death. How dare Pinki Virani say she should be starved to death, etc., etc. All the cultural stuff came in. after that, another justice at that time, a Supreme Court justice, who was one day before his retirement, the law was really bothering him. So he sent the whole law to a bigger bench. So it went from a 2-judge bench to the next higher, many other judges' bench. And in 2018, they upheld the law. So in terms of legals, you won't see a stronger law than this. 7 judges, all Supreme Court, all right? What they also did in 2018 was that they allowed what is called advance directives. Now, what is the meaning of advance directives? Let's not confuse it with living will. A living will is like a will, like a financial will, and you'll put whatever you want in it. But an advance directive is you saying, okay, if, God forbid, everything that has happened to Aruna Shanbag or has happened to Harish Rana, or even if I'm put on a ventilator, I would like ventilator to be stopped, whatever it is that you particularly want. And if you want your organs donated, whatever you want, the advance directive places your wishes after death has already set in. I have to clarify that legality, right? Now, we already, with the Aruna Shanbag judgment, because at that time I was living in Delhi, so I had already, some of us had already made sure that advance directives were already introduced in the Mental Health Care Act. But the Supreme Court put it in this also. So now we have an advance directive. Not only do we have passive euthanasia in India, which is the most tagada law now, unless Government of India reverses it, okay? That's important because Parliament has its own place and Supreme Court has its own place. And may I also draw the attention of your readers to the fact that just a couple of months back, Government of India has said it has no desire at all to change any law on the subject of passive euthanasia or advance directives. So everyone's good to go there. The law is stable. Now, to answer that part of the question, why don't more people know about it? Are we sure they don't? This is a case that has come to the Supreme Court, Harish Rana. And so we are getting more legal literacy, which is great, all right? It isn't that we want everybody to start doing passive euthanasia and all that. No, people need to know that they finally have a choice. You know, that's all. You have the choice. You don't want, don't choose. You want to suffer, knock yourself out, okay? The question here is, we cannot make a blanket statement that people don't know about it. You mean to say ventilators are not being shut off? You mean to say other procedures are not being followed? Of course they are. It's just that people haven't taken the trouble is wrong. Harish Rana's parents had to take the trouble. Everybody doesn't find it necessary to go till there. Of course, it's being followed, you know. So let's not work on the assumption that people don't know about the law. Oh, they do. But more legal literacy is always welcome so that people know their rights better and their choices better.
2018 Constitution Bench ruling allowing the advance directives or living wills and later procedural simplifications by the court. Among these changes, what do you believe have been the most meaningful for patients and caregivers and doctors on the ground?
Well, legally, it's all quite apparent as to how each additional step taken has been in the benefit of human dignity. It's hard, you know, human dignity, fighting for it, trying to achieve it. On the best of days, it's hard. And when it comes to when people are most vulnerable, and are people most vulnerable? People are most vulnerable when they are born. when you're in the middle of sexual assault and when you're dying, you know. So in the context of passive euthanasia, in the context of advanced directives, every step ahead, guided by the Supreme Court, assisted by the government of India, I think it's important to note that there have been different governments at different times of varying political stripes and thought processes. This would be equally true of the judges. But not one political party, not one judge, not one government has said no, no. They have understood, they have appreciated that what happened to Aruna Shanbag should never, ever happen anywhere in the world, because she is the only case of her kind in the world. They have understood, they have appreciated it, and they have acted on it. So every step taken has been important legally. I think above all, the most precious step, if I may call it that, is that all of this has made us, allowed us to make us feel, us as Indians, make us feel more human. It's given us a chance to understand that, yes, I'm free to, I have a choice, I can think like a human, I can be compassionate on my own terms. I'm free of God and guilt and log kya kahenge. I'm finally constitutionally being recognized by my own country, and its judges, its government, and myself as being mature enough to take a sensible decision if it's in the interest of the patient. I think that's the most important thing of all. The fact that I have been given, I as an Indian have been given a tool which is for me to examine whether I need to use it with compassion or not. It's giving me a chance to be human. It's a gift. It's a gift from Aruna Shanbag, who was never treated like a human.
Yes. Even with these legal safeguards in place, many families still struggle with uncertainty about the process, from the medical certification to court procedures and then hospital protocols. From your perspective, what gaps remain in awareness, healthcare practice, or policy that India needs to address to make these rights more accessible and humane?
So here's the problem that's coming up. In a sense, all the so-called safeguards and guardrails and whatnots are actually creating speed breakers. Not to mention complete, you know what the cops put up everywhere, those big barriers, those big yellow things? I mean, they're just lined up. I'm not sure what this says of how we think of ourselves, well, how we think of ourselves as a society, or whether government thinks of Indians as a society, or whether the courts think that only they have the right to think of how society functions, when society functions differently. Yes, society does function differently when it wants to misbehave. There's no denying that. And yes, so we do need guardrails, because like I said, that when someone's at their most vulnerable time. And that is why even if I approach part of your question with another legality, I must point out again that there is the advance directive. If you leave your advance directive saying that अगर मुझे ये हो गया तो मेरा ये करना है क्योंकि ये पैसिव यूथनेसिया जजमेंट लॉ अभी इंडिया में है, एंड सारे फैमिली से आप बात कर लो कि ये ऐसा है, that makes things less complicated. Your family then may not feel the need to go to a court. I'm not saying bypass the system. I'm aware that the system is now geared towards making it far more complicated and very time consuming. I might just die before my answer even comes from, waiting for the court's answer. So if you have a conversation with your family and your near ones and your dear ones and your loved ones, and you're able to sort it out at your own level, and you leave it all written and very clear, you've done your own job well, and you've certainly you've made it much easier for your family and for those who love you. That doesn't mean that they will want to do it or they'll jump at the chance to do it. My mother, she died when she was 49. She had just said it at that time. When I die, you have to give my eyes to the Duggan Eye Bank. This is when it was called the Duggan Eye Bank, and at that time the city was called Bombay. And that's what we did. There was nothing written, it was just said. My dad died after the passive euthanasia judgment. And he left a written thing saying, I want my eyes, my skin, I want it all donated. And whatever's left, just send it off for research for the children who are becoming doctors so they can see what's going on inside. Now, at that time, and so we told him after he wrote that, and we have 4 daughters and 1 son-in-law, and he made copies for everyone and he gave it to everyone. And we said, look, Dad, if you're going to do all this, then how do we bury, what do we do? And he said, it's just a minor detail, just deal with it, he said, at that time. At that time, advance directives had not come into play yet when my daddy died. But because he had this thing written, we were able to show it in the hospital. Within 2 hours, his eyes were donated, his skin was donated. Everything got done. Did I have a problem with letting him go? Despite having brought the law, despite having his written stuff, did I have a problem? At that time, I remember asking God, you really had to test this on me first, didn't you? I don't have a problem anymore because those were my dad's wishes. But that doesn't mean, as the eldest in my family, I didn't, it was awful. It was just awful. So we can have it all in place. All the legals, all the writtens. But still, when it comes down to it, it's awful. So at that time, if the legals are in place and if the written is in place, with patients' express wishes, I would request the doctors to not play God, because God has left that chat. It's now the person is already dead, legally dead. Legally dead, hi rehna baki hai. Everything else is gone. So I would really request the doctors and nurses to not play God, as they did in the case of Aruna Shanbhag. And I'm hoping that they don't play God in the case of Harish Rana. Please just give him what he needs, and which by his right he is now entitled.
Right, ma'am. That's all from my end. Is there anything that you would like to add on to this? Anything else that you would like to say further?
The more we simplify the subject, the more complicated it actually becomes for many of us, because it's a final. There's no coming back from this final. So each time there is legal literacy, let's weigh that against each patient who is already, for whom death has already set in. As we discussed briefly earlier, PVS is the worst kind, persistent vegetative state. It was not known up until the Aruna Shanbhag judgment, until Aruna Shanbhag actually was able to go through a process recognized by medicine as PVS. Till that time, PVS was not even there in the medico-legal dictionary of India. But because we were able to say this is what it is and it's PVS, and it got recognized in the medico-legal dictionary, if you now have somebody who's similarly in PVS, 10 years, 15 years, 20 years, know that the patient has rights. And don't make yourself. Examine whether the patient's rights supersedes your own sense of nobility. Do what is right by the patient. It is allowed by Supreme Court. It is allowed by Government of India. And above all, it may seem like it's not allowed by God, but because God has already left the room, it certainly is.
Right. Thank you so much, ma'am, for joining with us today on such a short note. And it was really good talking to you and moving to know all the details. We look forward to having more such sessions with you if required. However, let's hope not. So I'll just end the recording first.
Thank you. Thank you, PTI, for doing this. It's important what you have done, and I'm hoping that it increases the legal literacy. So thank you for making the time for it.